Often a beneficiary of an estate plan is going to be a minor, whether it's a child or a grandchild, nieces, nephews, or the like. And minors create another layer of complexity when it comes to transferring wealth to them. If a minor receives a benefit under a will, if it's an appropriately drafted will, it's usually going to have a provision that will hold that interest for them until they're at least an adult. Sometimes it's 18 or 21 or maybe later in life. But it will only apply to what the will controls. And so we have to make sure that we're aware of how the assets of any individual will flow if they pass away. The big problem comes where we either don't have a will at all, or where we're giving property directly to minors on a beneficiary designation, maybe on a life insurance policy or a 401k or IRA. And it's generally because minors are considered incompetent under North Carolina law and in pretty much every state. And it means that they can't legally exercise their own rights. And so if they receive a property benefit from your estate, from your assets, somebody who is their guardian has to open a guardianship of the estate to manage their property affairs, which is effectively an ongoing annual process that accounts for that property, establishes the use of that property to the clerk of court where you live or where the actual child lives. And then ultimately at 18, all that property is passed on to them because they're no longer incompetent by virtue of their minority. And so it's definitely not easy, not clean, can be costly and burdensome to transfer property in that way.